Okay. Good evening. Welcome to the Hillsborough Township Planning Board public meeting of November 19, 2015. Please join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, the Sunshine Law. Roll call, please.
Mr. Wagner?
Here.
Dr. Maroli?
Here.
Mr. Conard? Mr. Merdinger?
Here.
Mr. Julian? Mr. Beeson? Mr. Labate?
Here.
Vice Chair Cohn?
Here.
Committeeman Belcourt?
Here.
Deputy Mayor Burchett?
Here.
Chairman Dr. Solution?
Here. First item of business, disposition of the minutes of the October 8 meeting.
Mr. Chairman, Deputy Mayor, Committeeman, Dr. Maroli, yourself, and Mr. Lapani may vote.
So moved. Second.
Any discussion? Roll call.
Who did you say may vote?
Dr. Maroli,
Okay.
Mr. Burchett, Mr. Delcor, Dr. Cerisi, and Mr. Lapani.
Dr. Maroli?
Yes.
Mr. Labate?
Yes.
Committeeman Belcourt?
Yes.
Deputy Mayor Burchett?
Yes.
Chairman Dr. Solution?
Yes. Next item is the resolution for Richmond Properties, LLC, File 15, PB07MJV. It's the corner of Falcon Road and Sunnymead Road.
Everybody on the dais, Mr. Chairman, but Mr. Lapani.
So moved. Second.
Any discussion? Roll call, please.
Mr. Wagner?
Yes.
Dr. Maroli?
Yes.
Mr. Conard? Mr. Merdinger?
Yes.
Vice Chairman Cohn?
Yes.
Committeeman Belcourt?
Yes.
Deputy Mayor Burchett?
Yes.
Chairman Dr. Solution?
Yes. Are there any items from the floor for business not on the agenda? On the agenda are the two public hearings. Seeing none, we will go to the public hearings. The first is Cornerstone Professional Center, 751 Route 206, File 15 PB 13 SRV, Lot 200.02, Lot 13, Block 200.02, Lot 13. Applicant seeking preliminary and final major site plan approval with C-bulk variances, and this is for parking on an existing commercial site. Councilor?
Good evening, Mr. Chairman. My name is Vincent Michelli of Summit Associates. We are one of the managing members of 751 Highway 206 Associates, LLC. It is the owner of 751 Route 206, and I'd like to introduce Mr. Robert Highball, our engineer for the project, who will be introducing the variances that we seek tonight. Thank you.
Your first name?
You should be on speed
Robert
dial.
Ives on this business from your about to get a
I did.
Mr. Hybel?
Director of Professional Engineers, Professional Surveyor, Project, State of New Jersey.
Thank you.
Has anybody ever checked his credentials?
I know. I do that. It's once a year. It's done once a
You do
year.
that when you were chairman. This is an
Microphone?
application,
Microphone?
that we present-
Microphone.
Sorry.
Yeah.
This is an application that we presented to the board conceptually on June 11, 2015. The application is to construct 9 additional parking spaces on the easterly side of what is the existing Cornerstone Dental, Cornerstone Professional building. The purpose of the 9 spaces is that the applicant has taken title to the property, has a new tenant, happens to be OBGYN. They require substantial parking spaces. And the second half of that is the parking requirement within the zone is based on the usable floor area. They're going to convert some internal open space into actual floor area. So the ordinance requires 60 parking spaces. If the board approves this, there'll be 63. The reason I brought it here conceptually is the prior owner of the property and their engineer went up to the maximum amount of impervious surface coverage. I told the board, and happens to be 49.5%. I told the board that we'd go up about 2% if we put these parking spaces in, and that is the variance that we're seeking. We have 51.7%. There's a couple unusual circumstances around the property. Part of the conditions of the prior approval was that they dedicate the frontage along 206. I will tell the board that did not happen. So if the board were to approve this application, there shall be a dedication of the frontage as required. It happens to be a 17-foot dedication. Number two, as I told the board, the 9 spaces we are putting in with porous pavement. We went out, we did the soil test. I've spoken to Mr. White. He's absent at the moment, but he has issued a report. He reviewed the drainage calculations, etc. The 7 spaces are not tying into. There is an existing underground stormwater detention basin, which is near the front of the property. We're not tying into that system. This is independent of that system, and that's why we're putting the porous pavement in. One of the requirements by Mr. White would be, as the township has done on past applications, is that we have an easement around the porous pavement. I believe your township attorney has now, hopefully, David, has now drafted the form of easement, and we would take that form of easement plus a meets and bounds description from our office and file that. And if he hasn't, I'm sure he will. He has. Great.
Me.
One of the other factors was our client has met with the adjoining property owner, who I believe may be here this evening. On the northerly property line, there's a 6-foot high vinyl fence which is existing 2 feet off of that property line. Right next to that vinyl fence is his existing driveway. He's asked if we could take the existing 6-foot high vinyl fence and move it to the south. So part of this application would be to take up the existing fence and move it so that it's 5 feet away from the property line. With that, there'll be a private easement between my client and the adjoining property owner, and he plans to landscape that area within the 5 feet. Right now, if we put landscaping within the 2 feet, it would go over his driveway, and that's why he's asked that we do that. So that fence is going to be relocated the first 200 feet or so, and then it's going to jog over in the back. That would allow landscaping along the portion of the driveway where the house and the garage are. Also, there's been discussions. I guess I spoke to Mr. White and Mr. Bellinger. Once again, we didn't do the original engineering, but some of the storm catch basins tie into an existing stone swale, which then goes into the detention basin. The adjoining property owner says that some of the water actually goes onto his property. What we've proposed, and Mr. White's reviewed it and approved it, is to put some storm drainage in there, so we'll pipe it directly into the drain and not into that existing swale. It'll still go into the underground system, but there'll be no chance of overflow onto his property. And we've shown that on the plans. So my client has tried to be a good neighbor on some outstanding issues between this property and the property to the north. As far as the approvals, we did submit to the Somerset Union Soil Conservation District. We have under 5,000 square feet of total land disturbance, including the moving of the fence. So we have an exemption dated August 27, 2015. We submitted to the DNR Canal Commission. When the prior application was submitted, they were exempt. At that point in time, the rules were slightly different. This project is not exempt now, so we had to submit it to the Canal Commission. They've issued a report dated September 3rd. They have some conditions, including a copy of the resolution from the Planning Board of Approval, which we hope to get. So we will abide by any and all comments with the Canal Commission. We submitted the application to the fire marshal for the township. Upon doing that, we found that there was a markup in the prior approval where the fire engines would actually drive around and protrude 2 feet into the parking spaces that we're now proposing. So what we've done is we've actually increased the depth of those spaces by an additional 3 feet with the porous pavement. So that, and we've prepared an exhibit to show Mr. Wenninger. So when the fire engine goes around, it doesn't hit any of these 9 proposed parking spaces. The application was approved by the Somerset County Planning Board via their report dated September 17, 2015. And then we have the 2 internal consultant reports, one from Mr. Maskey and one from Mr. White. There are no outstanding issues that Mr. White and I haven't agreed upon. Some of the issues, once again, are to prepare a description for the porous pavement and file the appropriate easement. And there's a couple others, such as getting the Canal Commission approval. So we've agreed to all the items within his report. That takes us to Mr. Maskey's report. And we have no difference of opinion, though he can speak for himself. Part of the application was where the 6 of the 9 parking spaces, there's 2 existing trees that would have to come out. We have provided a landscape plan and showed those 2 trees. Beyond that, there's an additional 3 trees. Doesn't have anything to do with this application, but there's an additional 3 trees on the property that we found that were dead when we did our tree survey. We've shown replacing those. The board may remember that the prior planner that was sitting on the application at the time of the concept, Marcia Schiffman from Mazer, gave us another whole laundry list. That had nothing to do with this. It has to do with deficiencies in their opinion, in the current landscaping. Mr. Maskey has cited those in his report. Has to do with some trees that may die and some shrubbery in other places. Should the board approve this application, our landscape architect will actually meet with the landscape architect and the arborvitae, arborist, I won't get that word right, from Mazer, and we will address each and every one of those comments. So it's bringing the site back to where it was when the board approved it in 2009. The application requires 3 variances. The first one is for insufficient lot area. The current lot area is 1.896 acres. It's not being changed by this. That's what it is now. It will get reduced slightly because of the dedication, but we applied for a variance for that. Number 2, the requirement for the lot width is 200 feet. The lot was 190 feet. It will remain as 190 feet. It's an existing non-conforming, but we applied for a variance. And the third one is certainly the impervious surface coverage, once again going to 51.7%. And without going into further questions, I think that's a quick overview of the application. In my opinion, the application was reviewed by all the appropriate professionals, and I believe we've addressed each and every comment. The last one is that I did attend a meeting, we did attend a meeting before the Environmental Commission on September 28th. I will tell you that there were no issues. I checked with the Planning Board office this morning to see if there was a written report. Unless they produced one this afternoon, and I don't believe they have, there is no written report, but I would represent that we were there and that there were no outstanding issues.
Yes.
Just a couple of issues. Mr. Heibel, My comment 4.1, on a site visit, I found there was a drainage swale in the northeastern corner of the lot that was not shown on the plan.
Yes.
And the question was, if you move the fence in 5 feet, just from the naked eye, it would appear that the fence would actually be in the swale. Can you address that?
Yes, you're correct, and we've actually changed it, so the fence will get moved in the first 208 feet, and then the last 150 or so feet will stay exactly the same. And that is, I believe, satisfactory to the neighbor because the portion of the driveway is within the first 200 feet.
Okay, so you're only moving it the first 200 feet?
Yes,
And the last balance of the
Yes.
depth will be remain where it is?
right, absolutely.
Okay. One other question. With the increase in the size of the parking stalls, you've accounted for that now in the lot coverage. It was originally 51.5, now it's gone up to 51.7.
Yes,
That accounts for the larger spaces.
yes.
Okay. Thank you.
Just for the record, Mr. Conard has arrived at 7:50 p.m. Any other questions from the board?
Mr. Chairman, the last time the applicant showed up at a concept presentation, Mr. Hybel mentioned that in addition to moving the fence, that they had agreed with the neighbors they were going to put an 8-foot fence. They were going to put an 8-foot fence in. Where's the 8-foot fence?
I think what I mentioned...
I can give it to you on the record. I have it
No.
written and it's typed out. I could
Yeah,
show you what you said.
absolutely. What I said, Mr. Cohen, is that the neighbor requested to put an 8-foot fence to my client. I had indicated to my client that I did not believe this board was ever going to approve an 8-foot fence. A 6-foot fence is the maximum that's allowable. That's what's there
In
now.
what code?
In the Hillsborough.
No, there is not. There is nothing in the code that restricts the height over 6 feet. Mr. Maskey, do you want to answer that
To
question?
my knowledge, there is no restriction.
So we have not proposed to increase the height.
I understand. I just want to put that on the record.
Okay.
The neighbor can speak for himself.
Just wanted to
Very well.
catch you, Bob. That's all.
No, I didn't want to catch it.
That's
really
fine.
quite upset about it.
Any other questions? All right, motion to open public hearing.
So moved.
Second.
All in favor, say aye.
Aye.
Any questions from the floor? Yeah, come on up. And make sure you're speaking to the mic so I can hear you at home. He'll give you that one.
Commenting on Mr. Cohen's...
You have to say your name first.
Sandro Ianella. This is my wife, Eleni.
I know.
And we are the neighboring property. Yes, I agree. We did have a phone conversation about the 8-foot fence, and we also met on the property about the 8-foot fence. And going back on the video in the minutes, it was saying that the 8-foot fence would go up by my neighbor and with buffering landscaping because of our area and so how close the home is to this building that has been erected. That I do know. My question is about those additional spots, how we're going to make them 3 foot bigger. Obviously, there was a video that was put out of a fire truck could not get around. They had to back on 206. How are we guaranteed they're going to pull up all the way to the curb and allow that 3 feet extra for a fire truck if that ever comes after that parking lot's full? How do we guarantee that?
The only way we could guarantee it is perhaps if we stripe that area the first 3 feet and then put a small sign, maybe no parking in striped areas, something like that. But I understand the question. How do we know the car is going to pull up? Some people park at the back end of a parking space, and that is theoretically possible. So if the board deems it appropriate, we will stripe the first 3 feet.
Yeah, for like fire access
Yes,
only.
exactly.
Yeah, right. So, yes. I know I would park to avoid it if I saw all that striping, but, you know, good. Good point. Thank you.
will this be going further for more questions, or?
No, if you have questions, no, ask him right now. You're
Okay.
here. You
All right,
ask
so
him, yeah.
here's my story. Everybody knows who I am. Okay. So we live next door. We live there. I own actually two properties. I own that property and the next one over that I just redid. I don't know if you guys saw that. This district, and I can read it to you, is made in Gateway B for residential homes and residential homes converted into businesses, a lawyer's office or that type. You know, obviously, we know what it is. Or if anything's new, it has to have a residential look. This has killed us for the past 6 years, living next to this. I have ambulances coming in with lights. We have cops following the ambulances because there's an urgent care. It just became a burden on our home and our life. We walk out of our home, everybody sees us. It's just, we don't have a home no more. I know it's not their fault. They're the second owner. I definitely understand that. I got that. But we need to do something so we can get our home back. Everybody asks and says, "Son, you live on 206." Yes, we do. But that's what we can afford. That's where we live. Just like the people in Montgomery live on 206, those beautiful homes, and you can go to Princeton or up to Far Hills. Those are mansions on 206. Do people go to them and say, "You live on 206? This is where we made our home because we went by what the zone was calling for. A residential home, residential area. We do not mind living next to a lawyer's office or a doctor's office. That is fine. Dr. Pullen is across the street. He's my dentist. You have 4 or 5 people coming in. 6 people the max. Daycare, you have that big rush in the morning and the big rush in the afternoon. That's fine. But now we're having the urgent care, which is already there, I get it. Now we're having another business that is one of the biggest businesses. When you have a business like that, and I was watching that video, and this is true, because my wife is pregnant. When we got to meet, I'm going to meet her because I got to leave work. She's going to bring her car. I'm going to bring my car. Her mom's excited. My mom's excited. So who's going to come too? Now we got 4 cars to one client to that. I just can't understand how all these cars are going to fit in here. What's going on now in our home is 3 or 4 times a week, I have people shooting down my driveway, realizing it's not the urgent care, flinging out and actually going into the oncoming traffic to fling over. One time, and I have it on video, a lady drove over my lawn around the fence to get in. It has been out of control. The day this went up for the first variance, that was my major concern, and nothing was done. I don't know what to do with this home anymore. It's a home now. We made it our home. I have a home next door. What can we do just to get our home back? That's my question.
So, Sandra, is there something specific you're looking for? It sounds like there was discussion about the fence. I don't know if there was a misunderstanding about what's allowable and what's not, but it sounds as if it's allowable. And is that what you're looking for? Is there something else?
A buffer, a better buffer. Because a 6 foot.
What if instead of a full 8-foot fence from the whole length?
Mr. Cohen,
Oh, I'm sorry. Can we make sure, no one's ever accusing me of my voice not being loud enough?
that's not the issue.
Can we make sure?
The lawyer wouldn't be mentioning that.
Can
That
we-
would be from Kaz,
Can
if
we-
it was about your voice.
Yeah. Can we look at?
One second, Steve. Your concern, Mr. Bernstein?
My concern, the height of the fence is a discussable item. I really want to remind the board that the application before you is a variance for 9 more parking spaces.
Exactly.
That's it. We cannot undo what has existed. We cannot change what is there, other than if there is an issue regarding the fence that the board believes should have been addressed from the first application that wasn't, that's an issue.
That was the concept, though, wasn't it?
What?
That was discussed at the concept.
If the applicant is willing to go to the 8 feet, that's an issue. Otherwise, what else would you like is a question that cannot be answered unless it is directly related to the application at hand.
So, okay, let me answer that back to you. They're asking us, as the town, to provide them relief and it's not in the town's best interest to protect the health and welfare of the town based upon a variance that we're granting them.
You haven't granted it, Mr. Cohen.
But we may grant it when we vote.
Can I really ask that we sort of...
No, but I mean, you're saying to us as a board that we have no right to improve upon this property or make
No,
this
what you
a
have
better
no,
issue.
that's exactly right. You have no right to prove upon an application when all the applicant is asking for is a parking variance. That's it. If they came in and said to you they wanted to change the building, they wanted to make it bigger, they wanted to do something with the existing situation, that's a discussion. They are in here for 9 more parking spaces. You want to talk about
But they're
the...
also moving the fence, though.
They're moving the fence at a request of the neighbor. They are not
voluntary
required
action,
to move the fence. The fence can stay exactly where it is because, frankly, it's not part of the application.
The problem is that we're a planning board, not a board of commissars. We don't get to
I
have
understand
the
that. And
KGB
I agree
go
with
and
it.
tear down the fence and build a new one or anything else. You can only do what you can do under the law, which is hear the application and
So,
rule.
May I just a couple
And what's
of
the
points?
point behind a concept presentation, Eric? It's just a voluntary discussion?
That's exactly what it is.
is, yes.
May I just address a couple of points? In advance of any engineering or anything, we understood that there was an issue with some stormwater drainage, and I called Sandro at the time when we met on the property, and we walked the property. We talked about the flooding issue in the swale, and we talked about what are the most important things, and that was the sanctity of his home, the view that had been stolen from him by way of the construction of this building, and we tried to find a proper compromise between being a good neighbor as well as what is economically viable in order to accomplish what we were looking to do. With that, we flushed out some ideas. Number one was adding 2 more storm drains to that existing swale, the relocation of the fence back 3 feet onto our property line, an easement to which he could plant to give himself some protection from the visibility and from the cars and as well as the look of the building. Sandra and I have also talked just a time or two about a gate on the front of his house, which would prevent this drive-by traffic. So from a developer's perspective, we bought this building in its current constitution. We had an opportunity to keep within Hillsborough the Brunswick Hills OBGYN, which is a valued practice, and it will continue to remain in Hillsborough, serving the township. And I think that we have extended ourselves to the greatest extent possible by way of the relocation at our cost and expense, the additional storm drains, as well as the easement that we're providing. I hope that you agree that we've been fair, honest. In fact, I emailed Sandra this morning to remind him of this meeting this evening so that he'd have an opportunity to be heard on the issues.
okay, I appreciate that. I just asked him a question, what he was looking for.
Yeah, absolutely.
I want to hear what he wants, and then it's up to you guys whether you want to do it or not.
Moving the fence over is a good thing, but moving the fence means it's going to be lower in the swale. So the 6 foot now is going to a 3 foot or 4 foot, whatever the elevations are. So what's the point?
What about the landscaping buffer? Won't that help once it grows in?
When we're retired, I mean, by the time it grows and fills up. I mean, if Mr. Bernstein, what he's saying is we're just talking about the 9 spots, why would we all just get notified? Who cares about 9 spots? What's the point of us even being here?
Because the law requires notice to anyone who's within 200 feet of the application, of which you're within 200 feet. The issue is not notice or lack. The issue is that what the board has before it is a limited application. It can grant limited relief. If the parties agree voluntarily to issues outside the scope of the parking application and want the board to memorialize it in a formal resolution for ever and ever or lack thereof, that's another story. But for the issue before the board tonight is parking spaces, yes or no?
Yeah, you have to understand, we're operating under a state law called the Municipal Land Use Law, and we only have the authority to operate under which that law grants a planning board. And the authority is basically yes or no on what we're asked to judge on. So I guess the implied thing is, and this is the point, is that while we can't sit here and design somebody else's property, we still can say yes or no. So the idea being that if the board seems to want something to be done for you, then it behooves the applicant to see what they can do so that the board feels more amenable towards approving the application, because we don't have an obligation to approve the application. There are variances, and the board has can have the ability to turn down an application with variances in it, you know? So, I mean, it all depends. Of course, the applicant then could go to court and get a judge to overturn the board's decision, et cetera, et cetera. There's an interplay here, but part of it is not that we can just compel them to do something.
Right.
So the question is, what's reasonable? And also, it's not that you can't, I mean, you can come up and say, we want our home back, but that's not in our power.
Right.
The Board of Commissars could do that if it so wanted to, but a planning board, doesn't work that way.
Okay, so then I'll go by with the
So
nine spaces.
just so we're clear, which is why I asked you the question, right? For all of these points, we're not asking for design.
Right.
What is it?
Well,
You came
let me
up
ask
to
you
speak.
this question.
What are you looking for?
Well,
You've
with the
obviously
nine-
had discussions.
But with the 9 spaces means more traffic. The original applicant went for 1, 2, 3. Now we're going for 4, 5, 6. The traffic, when we have to leave that driveway, when the daycare is coming out of that driveway. Just the other day, was it 2 days ago, a major accident was just there because people cannot get it in. And now I looked at the survey of the area of the traffic. The survey that was submitted just talks about a daycare. They didn't talk about my driveway. They didn't talk about a dentist office and a home in the dentist office that comes out of that exit. They just said KinderCare. There are more people coming out of there that are out of control because you're not supposed to make a left out of there. People make a left anyway out of the daycare. But you have the dentist office, a homeowner, and a daycare. You have now additional 9 spaces means more traffic coming in and out, plus my traffic. That is a dead zone. This is so dangerous. You guys just have to see it. I know you don't see it because you drive fast by it up there. But when we're parked, or we're trying to get in and trying out, and everybody's fighting everybody. Like I said, there was an accident yesterday or the day before that I took pictures. Saw it happen. Everybody smashed into each other. Do we need a death? What do we need? We have children coming in and out of that KinderCare every day. We have my wife getting the mail right there as our mailbox. What do we do? My home was there when 206 was a dirt road. It was a dirt road. And what has happened to us is absurd. And why would the town come up with the zone for residential if they don't even protect us?
I wouldn't call Gateway B a residential zone as such, but it's a mixed zone, but I get it. It has residential in it. Mike, you were going to say?
Yeah, you're talking to a board that has been here for years. Sam Conard's house is on the map from 1860.
Correct.
Okay, so I have a rule. When I come out of a driveway like yours, I don't try and go across traffic. I make a right. Because making a left on 206 is crazy. And everybody that moves into Flagtown where I live, the first thing we tell them is stay off of 206. Just go across it. And that's what I've been doing for 40 years. You can't change that traffic, and not all that traffic is Hillsborough. So the safest and least risk is go with the flow of traffic that's in front of you, which is making a right out of your driveway.
And I respect that. But that's not the traffic I'm talking. I'm talking about people entering 206. That's the traffic. People coming from both sides is very, very dangerous.
There's many places. Sam Van Ness sat on this planning board, and he had Amwell Hardware, and he told me about an accident on the corner of Amwell Road and 206 every week. And there's many places that are like that.
The fact that 206 is no longer a dirt road has nothing to do with whether your house is there or not.
Yeah.
Well, it has to say
do
that.
with what's happened in New Jersey over many decades. It can't be. We can't fix it here.
Well, my reasoning when I
we
say
can't fix it here.
Right. But my reasoning is, when I say that, I can understand if I put the home later on. I get that. The home was already there. I didn't put the home there and then start complaining. My home was there originally. That's what I say when it was there since a dirt road on 206.
I don't think you put the home there. Probably your father put the home. I don't think you were born when 206 was a dirt
you know
road.
what I mean.
Just for the
Like
record,
your father
I mean,
put Central
okay.
Jerseys. We all have our father.
All right,
We're all rich.
so I guess the bottom line is you're opposed to this. But did you have anything else that you wanted to say specifically or ask specifically other than registering your opposition to this? I mean, that was, I guess...
Well, the question is,
Committee
two
of the Golf
questions.
Course question.
How do we prevent all that traffic because they put that driveway originally approval so close to my driveway, now additional people coming in with, I have my son running in the driveway. How do we stop that? I mean, it's going to be worse. That's where the question is when
so we moved away from the fence. I do have a question for Mr. Hybel.
I had the same question.
Yeah, because he's not sworn in as a witness, so he can't really testify to what's going to happen to the elevation of the fence. You are sworn in. If that fence is moved back as you have designed, does it dip in elevation?
Can you re-engineer it so that it stays high enough?
If it does dip.
In the back of the property, as Mr. Maskey said, when we went out there, it did dip. It actually went into the swale. The area that we're talking about, if anything, it's the slightest dip. I'm not saying it doesn't go down a couple inches, but it's not like in the back. It would have gone down 1.5 to 2 feet in the back.
So therefore, where you are going to be setting the fence back, it doesn't actually dip more than a couple of inches?
Yes.
Okay. So it still remains more or less a 6-foot fence?
More or less.
And there's no way to engineer a 6-foot fence to go up a little bit higher?
Well, come on, Steve.
Not the fence itself, the posts. You can raise the bottom,
Well,
right?
and
Without costing...
the applicant will speak for themselves.
Anything can be done for a certain cost, and I think that we balance a number of important issues. And the issue that was first and foremost when we discussed this project was the drainage, was the water running into the basement.
Right.
And I wanted to address that first and foremost. We're adding 2 more storm drains, tying those into our irrigation system. That is the costliest piece of this. If we want to start trading horses, we absolutely can. But that was the most important thing that was conveyed to me, that this basement is flooding, that and that we'd stolen a view. But I had nothing to do with this original building design or its original approval. We are just an innocent party here.
See, one of the things to consider if you're asking us to reject this is that you don't get the storm drains either.
Sorry?
You don't get the storm drains. You don't get the water remediated if the planning board was to deny this application, because the whole thing's been unfair to you. So there's a give and take here. So they are proposing things that would help you.
Ultimately, this is a matter of 1,500 square feet on the second floor were converted from common area into usable area for Brunswick Hills OBGYN, who is exploring the marketplace for relocation from Hillsborough. We had the ability to secure them a space. Despite the fact that code requires 4 spaces per 1,000, our user required, admittedly so, because they are a higher density user, a few additional parking spaces. In order to make our last remaining unit on the ground floor marketable, in order to ensure that we can assign parking spaces to that, we have sought out the addition of porous parking spaces at the rear of our property. Otherwise, that space remains vacant and dark for the life of the building, because we've got the urgent care that's got a certain amount of parking spaces assigned, Mona Lisa Dental on the first floor, and Brunswick Hills OBGYN. In order to make this building viable and full, we need the board's permission to add 9 porous parking spaces in the back. And in consideration of that, in an effort to be a good neighbor, we're willing to move a fence, add storm drains, and provide an easement agreement for planting on our property, which will provide shelter from the view from his residence to our building.
Those are the 3 leisure. Okay. Now, Mr. Hybel, about the question about traffic that could come into his driveway rather than your client's driveway.
Yeah, we actually did submit a traffic report, and we weren't going to have him as a witness, but Mr. Jay Troutman from McDonough Ray Associates is here to address any traffic. So if the traffic
Since
question...
it has been brought up, we can call him.
Yes.
Absolutely. If you want to sit down and listen to the traffic, and then you come back up, question him.
Yeah, but he doesn't.
It's Jay Troutman, Troutman.
TJ Trout is on this reference when you're about to get into the truth. Nothing to help you out.
Yes, I do. Good evening. We were asked to do a traffic impact statement for this application. The main focus of the statement had to actually do with the parking. In terms of traffic impact, the building's already there. The original traffic study that was done for the building used a number of 17,000 square feet. So even with the additional usable square footage, we don't come up to that number. It's already designed and approved to generate 17,000 square feet worth of traffic. So I really did not focus a lot on that, again, because it's an existing building. It's already allowed to generate a certain amount of traffic per the DOT permit that's been issued and per the prior approvals. The main focus was the parking, and the main point of the report was that we are bringing this parking supply more into compliance with what you see at medical office buildings. The Hillsborough ordinance is a little bit low at 4 per thousand for a medical use. The IT actually recommends, IT's Institute of Transportation Engineers, actually recommends a ratio more like 4.25. We're going to bring this up to 4.22. So the conclusion from a traffic standpoint was that we're, in a way, making the world a better place by providing a parking ratio that's more in keeping with the medical ratios that we found. I did hear the gentleman's question. I appreciate, the concern. I can see on the plan, and I can see when I was out there that those driveways are close. I don't know if there's any kind of, signage that would help, or if they would even want any kind of sign at their driveway. It's a private driveway. I don't know if there's any way to sign that or to somehow make it not look inviting to people who wander in there. I mean, that's the only thing.
A sign saying private driveway, do not enter, or something like that.
Yeah, I mean, perhaps there's something like that could be put up. Even if it stops one less person than is doing it today, that would be some relief.
Well, I believe that the homeowner said about 4 per week, which means that, many hundreds of cars per week are not making that turn. So if it stopped just a few people, that's exactly who it needs to stop.
Exactly.
Yeah. Okay. Did you observe, when you went out there and looked at the site, did you spend some time observing the traffic, or were you just, what did you?
Yes, we did.
Okay.
We did do some observations. We observed what the gentleman discussed about the Kindercare driveway. We observed the fact that that's connected also to the dental office. We observed all that traffic coming out. I actually put a stopwatch on it to see what the delays were like. It's level of service E, which you would expect along this area. People basically get out, especially on a left turn, when the traffic signals provide gaps, in the 206 flow. And there is a viable option to make a right turn without having a significant impact on, residential streets, because you could make a right turn out of these properties and go to Raider Boulevard and make a series of right turns and come out to a traffic signal at Homestead Road to make a left onto 206. That is actually a viable route.
Okay. Mr. Maskey, any questions?
No.
Okay. Board members, any questions? Okay, any questions? Yes. No? No questions? Okay. Thank you.
Thank you.
Yeah, come on. I thought you would have a question.
When they say easement, they'll make an easement so I can plant.
Right.
What does that mean? Is there a clarification? I'm not saying I'm going to put a building there. What can I do? What if I want to put up a pier? Maybe put gates at my cost. Obviously, looks like at this point I'm going to have to put gates. From the curb line to his line, I have a foot. I can't put a gate on a foot. I need a little more room. With this easement, will this be allowed?
We'd actually discussed that idea, that your fence would cross onto our property a bit, and we'd be entirely comfortable if it provided you with some security at the front along 206 to discourage any traffic from coming into your property. That the easement could include that. It would be limited to landscaping. We wouldn't ask that you build any permanent structures on our property, but it would run with the title of the property. And it
Well, the premise, it would be the gate here, so that's what I'm nervous about.
that can be incorporated into the scope of the easement that we extend you in consideration of the parking spaces.
So
Absolutely.
landscaping plus gate pier anchorage.
As
for a
long as
gate.
it doesn't interfere with our ingress or egress, we're comfortable conceptually with the idea. We'd like to see what it looks like, but yes, that's acceptable to us.
So I'm assuming the 8-foot fence is out, just from my house to the back.
Well, the 8-foot
We
fence-
discussed
the
this,
8-foot
he was going to stop.
That's between you two.
That we had discussed that on site, absolutely, and it was a consideration as we went further through the process and evaluated things of most importance as well as a cost-benefit analysis to the entire project. Relocating the fence, extending you the trees seemed to satisfy you at the time, and forgive me if I overstep, but seemed to satisfy you at the time, but the first and foremost concern was stormwater running into your basement, which, again, we had nothing to do with the original engineering of the building, but adding 2 more storm drains we think is going to eliminate that possibility going forward. I think
The storm drain I'm happy with. That
Good, I'm
should have
glad.
been from day one.
But again, we weren't involved in the
I
original
understand it
approvals.
wasn't you guys.
And these 9 porous parking spaces in the back, we expect to have 0 to no effect on your stormwater. So if anything, we're alleviating a pre-existing condition to our.
Well, I'm happy with the storm. I haven't brought that up. I'm happy with the storm drain. That's fine.
Good.
If the fence is not 6 foot high and it does drop and it goes up, what happens? See, I have to ask these questions because I never asked these questions the first time
Well,
the
no,
building went up. So I need
the
to-
fence is still a 6-foot fence. The question is just to what degree does the contour of the land drop? And the testimony is a couple of inches. Where the fence is going to be moved. If the entire fence had been moved much further in the back, but it's only going to be moved closer to 206 is the testimony. And in that area, it's only going to drop a couple of inches.
But that
That's
fence
the
can remain
testimony.
in its original position, in its original constitution, if we don't relocate it in order to extend this easement agreement for planting.
Right.
So it's an accommodation in 2 respects, that we are
Right.
relocating the fence at our cost and expense, as well as granting this permanent easement for planting.
Understood.
So you have their testimony on the record that it's not going to be a material change in your fence elevation.
Okay. But if it is.
That's
See,
a
here's the
good-
thing, and I know you guys
I
don't
know that's a good
construction.
que-
I know the
It's
grade.
it's a great question.
I know the grade, and the
you
grade
see-
is not going to do 3 inches. I
But
know.
if it is, we can only judge on testimony
Right.
and evidence. And the testimony tells us that it's only going down a couple of inches to where it's moved. That's what we have to go on.
Right.
So if you then say, well, but hypothetically, maybe it's not that, we can't go on that. We can't act on it.
And I understand that.
We can't act on
But
it.
I know the grade. I'm in construction. I know it's.
We're now having testimony. You want to be
But if you want to
I have an
testify
idea.
to a different grade, you can do that.
I can
What?
solve it.
Yes, okay.
Okay.
Oh, thank you. Yes.
Okay, and the client just agreed to this. What we will do is, where I think it goes down a little bit, we
Yeah.
will add fill in prior to resetting the fence, so that the posts in the ground will be no lower than they currently are. How's that?
Fair. That makes sense. That's
Okay,
how it's
well-
supposed to be done right.
Right. Well, you had to ask, not us. You had to ask.
Okay.
Very good. Okay. Excellent.
Well done, Steve. Is that okay, Eric? I just want to make sure you're happy because, it's all about you.
No, it's about the law, really.
After the meeting, Mr. Cohen, I'll be happy to tell you.
Yeah, well, you can do that. You can have that outside in the rain. But it's about the law. Okay, so what we've agreed to then is fill for elevation, the fence to go back where you said, a easement with the landscaping and the ability to have a pier for them to have a fence across the driveway. And,
Their own driveway, yeah.
and of course, their own driveway.
With an overhang onto ours.
Right, with the, because it's come over in 30 yards. And then the storm drain stuff.
Yes.
Got it.
And accessibility to a gate inside the 3 inches.
I'm sorry?
And also allowing them to use the their
How many-
property to put a gate in.
Yeah, that's the pier. Yeah, right.
Oh, I'm
right,
sorry.
right, right,
Is
right.
this to a review that it doesn't unreasonably interfere with our use of the property? Absolutely, yes.
Yeah, that's fine.
Absolutely.
Okay. Any other questions? Huh?
Private drives.
Oh, did you want a private driveway sign? You want a sign for those 4 people coming?
I think that's a good idea, that was brought up.
Your traffic consultant brought that, just little sign, private driveway for them, do not enter. It's just a little sign.
Are you asking me?
Yeah. Would you mind popping a little sign in the ground for them, private driveway, do not enter for their driveway, not yours, their driveway?
Sure.
Yeah.
Anything else, guys?
No. I thought that one wasn't too
Careful with that statement.
I thought we agreed to that. That's
No, it's
I didn't realize it was
your
our
consultant
decision.
mentioned it, so it's I could say that. Okay, very good. Any other questions?
Do we need
No?
a sign permit for that?
No.
Okay.
I made that decision.
This is Hillsborough, you have to ask about sign permits.
Actually, let's think about that.
No, let's not.
No, we have to now. This is
Why?
where we do that.
No. Those signs have to be. Those sign ordinance consideration for.
I'm not talking about the signs.
What?
I'm talking about the pier
The
that
pier?
he needs. The pier that he needs to put the gate up.
Oh, yeah.
It's going to be on their property.
Right.
Sandro's going to go for the permit to do that, so he's going to need something that's going to allow them to
No,
do
the
that.
easement has to say that that's permitted.
It will include that.
Yes, the easement will include that. The easement is for landscaping and that.
Okay.
Yeah.
So we have
no,
some-
that yes.
Okay.
That's right. Okay. All right. Anything else? Motion to close public hearing.
So moved.
All in favor, say aye.
Aye.
Okay.
Motion to approve file 15-PB-13 SRV.
With all the grievances.
With all the
All
grievances.
variances. I'll second that.
Roll call, please.
Mr. Wagner?
Yes.
Dr. Macaulay?
Yes.
Mr. Connor?
Yes.
Mr. Carpenter?
Yes.
Mr. Lozani?
Yes.
Vice Chair Collins?
Yes.
Lee Van Delcourt?
Yes.
Deputy Mayor Burchett? Yes. Chairman Dr. Sweet?
Yes.
It's been a
Thank you.
pleasure. Thank you.
Yeah. It has? Okay.
You must be here, Leonard.
All right. Boy. Okay. So, any, no, do you, not that much. Do you want a break? Do you need a break? Do you want a few minutes?
Why don't we take 5 minutes?
We'll take 5 minutes. Take a break. I signed. Okay, we're back. Second public hearing, Gibraltar Quarry, KDC Solar, file 12 PB01SR, block 174, lot 155, 484 County Road 601, Belmead. And this is for a solar array at the quarry. Counselor?
Yes, Richard Shosford, attorney. As mentioned, Mr. Chairman, that's where we're looking for a preliminary and final site plan for a solar array on the so-called tailings pile, 11.2 acres on the 549.9 acre site as the quarry, the O3M quarry, now owned by Gibraltar Rock. I advertised for an existing building which we're not touching, nor is it expanding, but it exceeds the height of the quarry zone. And I did that because the last time we were here in 2011, and you'll hear that we've changed a lot of things since that time. We moved basically the quarry off the mountain into the tailings pile. But at the time we did it in 2011, Bob Ringelheim told me to put that in, but we're not changing anything with respect to the building. And lastly, we're not looking for any variances, but we need a submission waiver from section 188-32E of the ordinance regarding the community impact statement, since what we're doing doesn't, if you read the ordinance, affect the community whatsoever, i.e. school children, it's traffic, etc. As mentioned by you, Mr. Chairman, it's on the east side of Long Hill Road between Zion Road and Dutchtown Zion Road. It's known and designated as Lot 155, Block 174. It's in the quarry zone that we're doing the quarry, but part of the property, which is a 549.9 acre piece, is in the Mountain Conservation District zone. Again, we have, I'd like to just have one witness go through give you an overview and clear up the few odds and ends that Mr. Brown, your substitute engineer, brought out, as well as Mr. Maskey's memo brought out to clarify any issues, plus, of course, any issues that the public has or you have as members of the board, we would clear up as well. There is, I just want to mention, just for the record, a letter from Michelle Donato Esquire, who represents the Sauerland Conservancy, wrote a letter to me, copying Deborah Paget, saying that they no longer oppose the application. If you recall, in 2011, some of you folks were here then. There was a big opposition because we now move the quarry of the solar panels off of the mountain into a part of the quarry, and you'll hear more details again on that. So there's no trees or vegetation that will be cut down. So, without further ado, I'd like to have Mr. Robert Morcello, who's a licensed PE of the state of New Jersey, be sworn in and give briefly his qualifications and give you an overview.
Mr. Morcello, and you use the microphone, please.
State your name and spell your last name.
Robert Moscello, Moschello.
And Mr. Morcello, you're a licensed PE of the state of New Jersey? Oh, I'm sorry.
Robert Morcello.
Yes, it is.
All right. Mr. Morcello, you're a licensed PE of the state of New Jersey, am I correct?
That is correct.
And these plans were either prepared by you or under your direction?
That is correct.
You visited the site?
I have been to the site.
And you are familiar with the Hillsborough Township Land Development Ordinance?
That is correct.
And municipal land use law of the state of New Jersey?
Yes.
And you've appeared before planning boards, zoning boards in the state of New Jersey?
Yes, I have.
You've qualified as an expert?
I've been qualified as an expert
I
witness.
submit him as an expert, members of the board?
That's fine.
Okay.
Please
Thank you.
proceed.
Excellent.
Okay, and you want to give us an overview of the proposal?
Sure. I have a couple of exhibits that I'll be going through tonight as part of my presentation. I'll just enter them as I go. Is that okay?
Yeah.
Excellent.
Yes.
So, the first exhibit I have here is, we'll entitle it A-1. Is that okay?
Yeah, mark the date too, please, 2015.
First exhibit is entitled Vicinity Aerial Exhibit. It's dated November 19th, 2015. It's Exhibit A1. And what we're looking at here is the 2012 New Jersey State aerial photograph that shows the surrounding environs around the quarry sites. I'll point out a couple of the landmarks and features, the north being straight up on the plan. We have the municipal boundary line, which is the thick orange line on the plan that separates Hillsborough Township on the northwest side with Montgomery Township on the southeast side of the plan. You have County Route 601, which is where the main access is. That's in Montgomery Township to the quarry. The main access drive is actually in Montgomery Township on its own block and lot. As you come up the main access drive, you cross over the municipal boundary line into Hillsborough Township, where the main quarry operation takes place. That is known as Block 174, Lot 155, and is approximately 550 acres of land that the quarry operation takes place on, and that's within the quarry zone. Some other landmarks you have is Dutchtown Zion Road, which runs in an east-west direction southerly from the quarry, Long Hill Road on the western side of the site as well, and then you also have the rail line that runs in an southwest to northeast direction that actually accesses the quarry as well. Some other features, you have the Carrier Clinic, which is to the northeast. You have some existing office buildings to the south of the facility site as well. The next plan that I have, we'll title this one
Dated as well.
Dated November 19th.
This is entitled Environmental Constraints Exhibit, dated November 19th, 2015. This is a conglomeration of the environmental constraints contained within the site plans plus the 2012 state aerial. So now what we've done is we've rotated the plan slightly. North is now to the upper corner of the plan sheet. The municipal boundary line is actually running along the bottom of the drawing now. So we have the 550-acre quarry area that's within Hillsborough Township. And we can talk about some of the features of the property. You have when you come into the property, you have the processing plant and the existing office areas that are there when you first come in across the municipal boundary line. To the northeast, north, you have the existing mining quarry operation that's taking place here. We have the area that's going to be really the subject of this application, which is the tailings pile. Then you have existing wooded areas that are surrounded on the western portion of the site, southern portion of the site, and a small portion of the northern area of the site. As far as environmental constraints go, there are wetlands on the property in state open waters. They were delineated as part of an LOI that was done in 2014. Those wetlands both have 150-foot buffers and 50-foot buffers on them, and the area is shown in green on the plan here at various points throughout the perimeter or the edges of the property site itself. There's also some state open waters which have riparian zones associated with them. Those riparian zones have 150-foot buffers on them, and those are shown with the blue dashed lines you see on the plan here at the various points throughout the site. The site's actually part of two smaller watersheds that eventually all drain into the Pike Run. You have the Roaring Brook on the northeastern side of the site, and then you have the Back Brook on the southern portion of the site that eventually both of those do come back together as part of the Pike Run watershed. There are steep slopes on the property, most of them which are associated with the man-made quarry operations that have taken place. Those are the shaded areas on the plan here. You can see that the areas around the quarry are essentially shaded in slope areas. You have the slopes that are associated with the tailings pile, shown in gray, shaded in. There are a couple areas of natural slopes in the wooded areas on the western portion of the site and on the southern portion of the site, just to the south of the tailings pile, which I should point out, this was the area to the south of the tailings pile where the application was originally proposing to put the solar array a couple of years ago, and where now it's since been moved from. This next one will be entitled A3, which 11/19/15. This is an overall proposed site plan exhibit. Same orientation as the environmental constraints plan. What we've done here is we've now superimposed on this the solar layout to give everyone a sense of its location in relation to the rest of the features on the property. So here's the tailings pile. And what we've shown here is the array solar layout shown on the top of the tailings pile. And then from here, there's actually going to be a conduit run, and we'll get into more detail about this, coming down from the tailings pile, which will actually connect into an interconnection point in the middle of the processing area of the quarry. That is where the electrical connection will take place for the power from the solar panels will actually tie in to the physical electrical systems that are on the quarry site. So from this plan, I want to zoom in a lot closer now to the actual solar layout itself to talk in more detail about that proposed layout. So this is entitled Site Plan Rendering. It'll be A-4, also dated 11/19/15.
What? A3 is what he just showed us. That's showing the.
So we'll talk about some of the different components and the layout of the solar facility here. This is a 40 scale plan that blows up the solar facility on the top of the tailings pile itself. We have the access drive that comes up from one of the existing access drives within the quarry site. I should point out that this access drive is about a 7% slope. I believe there's a comment in the fire official's review letter to confirm the slope of that drive. Anything we would want it to be less than 12%. It is. It's approximately 7% slope coming up to the site itself. It's a stabilized gravel base that you can certainly drive up onto what is a gravel drive area that basically terminates towards the eastern portion of the tailings pile that's there today. That provides access to the top of the pile. As you can see, we have the proposed solar layout here. One of the things that you can see on this plan is a white outline that represents the top of the slope of the tailings pile itself. So from that white line going down, those are your 2.5 to 1 slopes that represent the steep slopes that are the side slopes of the tailings pile itself that goes all the way down to the base of the mound. The design that we have here takes into account a certain setback from that top of slope line, so this way we don't have any impacts on the stability of those slopes on the tailings pile. So what we've done is we've maintained a 25-foot setback based upon discussions with the geotechnical engineer from that white line to what is the yellow line shown on here, which is our fence line that surrounds the solar facility installation. And the area within that fence, I should point out, it's approximately 11.2 acres in land area. So from that 25-foot setback, we have at least another minimum of a 10-foot setback between the fence line and the closest panels so that we have some circulation for small maintenance vehicles around the facility for purposes of maintaining the facility. Then within there, we have the solar array itself, and I'm going to go through some of the different components that make up that solar array, starting with the supports for the array, which are going to be a series of posts that are driven into the tailings pile itself. They're typically I or H type posts, steel posts that are driven anywhere from 4 to 6 feet into the ground with a pile driving machine that's going to support what we call the racks, or the racking system that the panels are actually placed on. So we'll drive 2 posts, and then we'll do a series of connecting metal beams that will now support the solar panels that are placed on top of them. So what we end up creating is a series of, we'll call them tables that they refer to in the industry, which is made up of approximately anywhere from 20 to 30 solar panels, and in this case we have 5 panels in portrait that go across and then we have 7 panels in landscape. I'm sorry, 6 panels in landscape for a total of 30 panels that make up 1 table that's supported by 2 posts. And we have a series of those all across the site. And there's approximately 660 posts for the whole installation, and each of those posts represent approximately 0.02 square feet of coverage area. So we're talking about 13 square feet in total impervious coverage for the posts themselves. So you have the posts, you have the racks, you have the panels which are attached to those racks, and then from those panels you have conduit or electrical conduit that's taken to a central area on the site, and that's the area where the inverters and transformers are located, and that's generally right off the access road, right in the middle of the facility here. That is where the DC power that's generated from the solar panels is converted to AC power through the inverters. And then from those inverters, they're connected to a transformer, which then boosts the voltage so that we can send it approximately 3,500 linear feet to the center of the processing plant, where it's then tied into the electrical systems for the quarry usage. There's about 1,200 square feet of concrete pads here for the different utilities. We have the inverters, the transformers, and there's also a switchgear pad, which would allow us to disconnect the system from the connection point should the need be to do that. I should point out that the fencing that goes around the perimeter of the solar panels is an 8-foot-high galvanized fence. There's details of it on the plan, but typically it's a typical 8-foot-high galvanized fence that's used that goes around the facility with a gate that is closed and prevents access for security purposes based upon the electrical code for preventing access to the facility. In terms of site grading and stormwater management and vegetation management on the tailings pile itself, this project is not major development. It doesn't generate more than a 1/4 acre of new impervious surface. It doesn't generate an acre of disturbance. And essentially, we're not proposing to change any of the vegetation on top of the tailings pile. We understand that a number of years ago there was some issue with dust runoff and sediment runoff from the pile before it was quote-unquote stabilized. So since that vegetation has taken hold up there, we understand it's an invasive species. Our environmental consultants looked at it. It's pretty sturdy in terms of its ability to grow, whether it gets shaded or anything to that nature. So we're not looking to remove that vegetation and replace it with something different. We're just going to leave it up there and let it continue to act along its normal path and continue to grow. We will maintain the height of it, although. There was a comment in the fire officials review letter to keep it to 12 inches under the panels. We have no problem with doing that as part of regular property maintenance. But it will be maintained up on top of the tailings pile. As far as grading goes, there's no grade change being proposed on the top of the mound itself. The drainage patterns that are there today, which basically go to a series of collection pipes, you can see some of them on the aerial here, which are a series of pipes that go down the 2.5 to 1 slope that convey runoff of stormwater from the top of the pile down to what are a series of sediment ponds at the base of it. Those pipes are going to remain in place. There's no plan to change those pipes or modify those pipes in any way, shape, or form. So the runoff the way it comes off the mound today will continue to do so in the future. And since the panels technically are not impervious, they just sit above the grade, the water is going to just sheet off onto the surface anyway, and it will continue to sheet that way once the system is put in place. In terms of zoning, it's just simply, as mentioned before, it's a permitted use within the zone. The solar panels, there's no change to any of the bulk zoning. There's no variances being requested as part of this application, and it complies with all your requirements of your zoning ordinance. The next exhibit that I have, I'd like to put up, will be Exhibit A5. This is entitled Vicinity Aerial Exhibit with Viewshed Studies. It's dated November 19th, 2015. What we've done here is we've taken the overall aerial plan and we've placed the panels on there, and we've taken a couple of Google Earth images of the facility from a couple different vantage points to show what would be visible from the top of the mound in terms of the solar panels. The panels themselves are a maximum height of 8 foot, which is the same height as the fence, but the fence doesn't actually provide any screening. It's an open fence. And we want to show what would actually be visible from distances such as the Carrier Clinic, which is about 1.9 miles from the tailings pile, the existing office building to the south, which is 1.4 miles from the tailings pile. And we actually took a view from the water tower, which is actually which is visible from the surrounding area, which is 1,000 feet from the tailings pile. And I want to point out that because of the location of the panels and the setback they are from the edge of the tailings pile, where the closest panel is 35 feet from the top of slope, because you're set back, and this is the highest point you're looking at in the area, and you're down low looking at it, your angle of eyesight actually looks beyond the tailings pile. So because they're set back, you don't see the actual panels themselves. So these views that we've actually put together from the Carrier Clinic, the before view without the panels, and the view with the panels, there's really no change to them because you can't see the panels from a distance because of your angle of view looking at the array. Same thing for the view from the office building. You can see the mound, you can see the tailings pile, and you can actually see the water tower just to the right of the tailings pile, but you can't see any panels on the top because both distance and the angle really make them imperceptible to the eye. If you are from the base of the water tower, you can see, and I'll point it out on here just slightly, if you look at the view that we have from the base without the panels and the view with the panels, you can see there's two little bumps that show up here, and those are the actual panels. If you're standing at the water tower, you might actually get a glimpse of them. That's actually inside the property at the base of the tower looking up at the tailings pile. So this actually goes to a comment that was in your planner's review letter about the buffering requirements of the site itself for panels such as this. The buffering really is the distance that we have here from the surrounding environs that provides that buffering or screening to it, and the height of the mound versus everyone else looking up at it provides the screening that you really don't see this facility from a distance at all. I'd like to take a few moments to go through the rest of the review letters that were put out. We mentioned that the Sauerland Group issued a letter that they have no comments with the application. Mr. Brown put out a review letter that had a couple of items that I want to touch on. One, there was a comment about a survey that was prepared for the application. We've referenced our plans based upon two surveys. One was a wetland survey, which also referenced another survey done by Stiers Associates of the boundary. We could provide a copy of that for your files. Another issue had to do with, there is a series of, I'm going to go back to Exhibit A4. Coming up the main access drive, there's a series of gravel berms that act as diversion berms to slow down any stormwater runoff that comes down that drive as part of the stormwater management for the tailings pile. We are going to have to excavate through those berms to put in the conduit to the connection point, and we'll put a note on the plan that those berms will be restored once the conduit is put in place. No vegetation will be removed except for the purposes of installing the utility pads. That'll be the only vegetation removed. The other vegetation will be maintained. I know there's some comments in some of the reports that were conflicting about we might be replacing the existing vegetation with meadow grasses, but that's not the case. The existing vegetation will remain on the tailings pile. As far as third-party approvals are concerned, Somerset County, we just received their planning board approval today. I'm not sure if the board even has a copy of that yet, but we just got that in this afternoon. Soil Conservation District had some minor comments relating to soil erosion measures, which we'll address as part of any approval we may receive here tonight. Delaware Route and Canal Commission, they reached out to us asking about the extent of the project, whether or not we meet their development requirements, being an acre of disturbance. We responded back to them that we're not an acre of actual land disturbance, and we haven't got their jurisdictional letter yet, but we're anticipating that shortly. But we will comply with any comments or concerns that they have as far as this application goes. I've spoken to them already, and they didn't seem to have any issues with the application, but we certainly comply with any comments they have. As far as Montgomery Township is concerned, we've spoke to their principal planner, Laurie Savron, who's made mention that both the planning board and the planning department has no issues with this application, and Mr. Statsman can certainly provide some additional information on that.
I represent to the board that I did speak with, I'll represent to the board, I did speak with Laurie Savron, and she said they have no issues with the application whatsoever. We did notify...
Can we get a letter to that effect?
What's that?
Can we get a letter for the files, Mr. Schatzman, to that effect?
Yeah, if you want. Yeah,
Please.
she'll write a letter. Sure. She'll write a letter. Sure.
And then the other memo we have is from a couple more memos, but the first one is the fire official. He issued a memo dated November 16th with 3 comments on it. One of those having to do with the slope of the road, that's less than 12% coming up to the pile. One was the vegetation, which will maintain at 12 inches. The other comment was providing access around all sides of the array. Roadways must be designed to allow for fire apparatus safe access. We've actually met, representatives both from Gladstone Design and KDC Solar met with the fire official earlier today to go over that specific comment because we were concerned about having to put some type of ring road around this facility between the fence and the panels. And in meeting with the fire official, we came to an agreement that, and I'm going to enter this as Exhibit A6. This is entitled Modified Site Plan Rendering, dated November 19th, 2015. Speaking with the fire official, we've came to an agreement that he would prefer to see a radial access, a linear access gravel drive that would split the panels down the middle, that would provide him access to the rows from the existing gravel drive that's there. And in doing that, we'd have to take a couple of tables and relocate them towards the northwest side of the project, increasing the limit inside the fence from 11.2 acres to approximately 12 acres to satisfy his comment about adding the additional gravel. We would look to still stay a net no increase in impervious coverage, so we would remove additional gravel that's on top of the tailings pile to keep the increase of impervious to 0 or less than what was currently up there today. So in meeting with him, we discussed this, and he felt that that would satisfy his concern about access to the rows of panels, as opposed to doing a loop road around the facility.
Before we get away from Mr. Brown's report, maybe I missed it, but he also asked on the geotechnical engineering report, in the conclusion recommendations under earthwork on page 7, it states that, quote, site preparation generally begin, threatened endangered species habitat suitability assessment. Proposed limit of disturbance in the Trident report, figure number 3, depicts the location that was presented in the prior application. The applicant should confirm that the conclusions contained in the report are applicable in the proposed solar array location for this application.
Yes, our environmental consultant issued a letter that that in terms of the conclusions for the T&E, and that there's no impact of threatened or endangered species from this facility on top of the tailings pile.
Okay, I think we covered Mr. Brown, but he can speak for himself. You want to go to Mr. Maskey's November 10th report,
that is
please?
Correct. There's a couple comments in his letter I'd like to touch on. I spoke to this is on page 3, dealing with the couple different items here. One is the buffering requirements, which I believe I touched on already in terms of the view shed study that we prepared and the distance that the facility is from the existing environs. The next item.
Let me just fill in as you go along. So it's your testimony that there is no other properties close by to the property line that would residential or otherwise, that would see the solar panels?
That's correct. The closest property is about 3,000 feet away to the south, and because of the angle with the trees and the vegetation, the panels would not be visible to them. The next comment is describe the relationship between the owner-operator, which is KDC, and the property owner, Gibraltar, as it relates to the responsibilities for maintaining and the eventual removal of the solar panels, as noted. Essentially, the way the agreement works is that KDC Solar is the owner-operator of the facility. They have an agreement with Sylvie to construct the facility on the tailings pile, operate the facility, and then provide the electricity to Sylvie or Gibraltar as the power provider. It's their sole responsibility to maintain the facility throughout the life of its operation, which in this case I believe is a 25-year lease on the facility. And anything that was to go wrong with the facility, they'd have to repair and maintain it. It's not the quarry's responsibility to do that. At the end of the 25-year lease, it's then KDC's responsibility to remove the facility from the site and restore the property to its existing condition. And there could be a decommissioning manual that could be provided to the board that would lay out those essential steps that take place at the end of the facility to remove it from the site.
But the ordinance puts the responsibility for all that squarely on the owner. So we would need something in writing to the effect that the owner and the operator are in agreement that the responsibility is somehow being shifted to the operator, not the owner, because the town's going to hold the owner responsible.
Okay.
Mr. Schatzman, can we also get...
Yeah, I'll take care of that.
Can we also get a copy of the lease and the decommission manual, please?
Okay.
In terms of the emergency access and security measures, I believe I touched on that already with the discussion with the fire official.
Yeah, just related to that, is there going to be any security lighting up there?
There's no lighting up on top of the facility. There may be some cameras that may be installed in and around the equipment. Since it's an unmanned facility, generally KDC Solar, they manage their facilities remotely with monitoring equipment to keep track of the electrical output and the inverters and transformers. So there may be a few cameras. We're not sure as to how many, but usually they're focused around the key components.
Enclosed by fence with a lock gate.
Correct. The fence will be locked.
Yeah, there's a detail on that on the plans, if you look at it.
As far as the T&E assessment goes, I believe that information has been provided. I don't know if we need to provide anything else with that. We talked about the cover underneath the panels, that the vegetation will remain, it will not be removed.
Let's go on to that one a little bit more. Now, obviously, as I pointed out in the one report, it specifically says there will be no loss of trees, et cetera, but the area will be seeded and stabilized with herbaceous ground cover. Pasture seed mix was noted, which will grow beneath the solar panels. Now, I understand you're not wanting to disturb what's up there, but you will be disturbing the ground to some extent during the construction process. Are you going to go back in and restore the area, seed where necessary?
Yes, any ground that's disturbed, whether it's from trenching of some conduit or anything that is disturbed, will have to be reseeded as part of the site plan process so that we don't leave exposed material that could be subject to erosion.
Thank you. And I'll skip ahead for you. The geotechnical report, there was a series of recommendations. Again, they were just recommendations from a consultant for the applicant regarding things that should be done during construction, et cetera. Are you going to follow all those recommendations?
Yes, we are. Yep.
Thank you.
All those, it's throughout the report, Mr. Maskey, and we're going to take care of that and abide by all the recommendations.
One other review letter I'd like to touch on or is the letter from the Environmental Commission, Hillsborough Township Environmental Commission, basically stating that they have no concerns with the project. We went before them, we presented it, and we discussed it with them. They have no concerns. That essentially concludes my testimony as it relates to the application.
Mr. Maskey, do you have any more questions or comments? Or
None at this time.
Okay. Mr. Brown?
Yes, Mr. Michello and I had a brief conversation regarding the actual installation of the piles. You may want to touch on how you're going to treat the ground once the pile's installed.
Yes, actually, there's a detail on the last sheet of the plans and the detail sheet that talks about and I had this discussion with Frank Calla from the Soil Conservation District as well. Just since we are going to be driving piles into the ground, there is the chance that you'll get some soil separation from the piles as they're driven. We've actually provided a simple detail to provide a small little clay cap around the pile itself, a 6-inch high clay cap, just to prevent surface runoff from getting into the area between the pile being driven and the soil, just as a means to keep this water on the surface and not let it seep into the tailings pile where we can. And that would be on each of the piles that's driven into the ground.
I see. That's you're referring to the drawing on the lower right, where
Yes,
it says clay soil mounded basic
Correct.
pile. Right.
On the fixed rack ground mount array detail, you'll see it there in the lower right-hand corner.
And that's also in the geotechnical report as well. You read that. It also has a clay core provision for that we said we would agree to, and he put it on the plan, so it's done, noted twice for this application.
Mr. Brown, please continue.
Nothing additional, Mr. Chairman. Thank you.
That's it. Okay. Questions from the board? No? Okay. Motion to open public? All in favor, say aye.
Aye.
Questions from the member of the public present? No doubt. Peg? Use the microphone, you know.
Is she giving testimony or?
Yeah.
Oh.
No, that's all right.
Is she an expert?
Peg Van Patten, Skilling, New Jersey. Peg Van Patten, capital V-A-N, capital P-A-T-T.
Peg, are you going to be delivering anything that might qualify as testimony?
This is not going into evidence. I just have it here.
I just saw the bag in the jar. I thought maybe you would be. I don't know. Just a guess.
I thought she was cleansing.
Well, you know, I was thinking something else too, but as a physician.
Okay.
But
Mr. Michelle, I wonder if we could
Peg,
I ask
one thing. No, if you did bring something to show, I think it's probably best that you be sworn in because you're going to have to give like provenance. Where did you get it and all that? That's testimony itself.
Mr. Chairman, question though, do I have to give it up? This was actually used at a prior hearing on this subject. It's already marked.
Yeah, you're going to need. You need to use. You know what?
Either sit or you can stand.
Yeah, you could also stand by that because I know you can't hold the mic, but sit by that mic right there, and so you make sure that you. Yeah, that's why I got it for you. As far as the question of where.
Let's get her sworn in.
Yes, let's get you sworn in because you're going to talk about where you got that and what that is, and that needs to be. You need to be sworn in for that. So if you please swear her in. Peg, swear in first.
I do.
Okay. Go ahead, Peg.
Okay. I'm going to sit down. I am going to sit down.
And then get the mic right in front of you. Okay.
Okay, I'm going to ask you a couple questions about the maps. Would you mind returning to those maps? Sorry.
No, not at all.
You made some comments about wetlands, okay? And you said some were 50 and some were 150. I couldn't, unfortunately, write, so for me and for members of the public, and especially for members of the board, would you please, Mr. Michelle, please explain what's the difference between 50, 150? What does it mean? What's the significance of it?
Yes, there. Yes, I'm referring to Exhibit A2, which is the Environmental Constraints Exhibit,
Okay.
dated November 19, 2015. NJDEP has different classifications for their wetlands.
Could you hold the microphone up closer to your mouth so we can all hear you?
NJDEP has different classifications for their wetland categories. Here there's 3 different types: is ordinary, intermediate, and exceptional resource value wetlands. This property, through the LOI, has both intermediate value wetlands and exceptional resource value wetlands. The intermediate wetlands have a buffer of 50 feet. The exceptional resource value wetlands have a buffer of 150 feet. Typically, the difference between the 50 and 150 has to do with the presence, whether it's on-site or just downstream of the site, of threatened or endangered species that would trigger a larger buffer on a wetland complex.
Could I stop you there just a second? Because the board doesn't want to hear all this stuff, other than to say exceptional value actually sounds better than intermediate. Do you have clearly marked on your map which ones are intermediate, which ones are exceptional? I have a reason for asking you that.
Yes, I do. As a matter of fact, the wetlands, and I'll go around in a clockwise location, starting at the very top of the plan, which is the north, closest to Long Hill Road. The wetland complex up on the upper portion of the plan is exceptional resource value. As I move in an easterly direction along the property line, that is also exceptional resource value wetlands. Then if I come down to the southeast, where I hit a wetland complex in the lower right-hand corner of the plan, that is actually an intermediate resource value wetland, which has a 50-foot wetland buffer. That's actually the only one on site that shows up that way. Actually, there's also one in the middle of the site that's intermediate resource. But then going around the rest of the boundary to the south, we have exceptional resource value wetlands to the south of the tailings pile. And then as I come back around in the clockwise way towards the western portion of the site, I have an exceptional resource value wetland that's along the western property.
Sir, what did you say the one down at the bottom, closest to Hillsborough is?
The bottom right, or
No.
the left-hand side of the plan?
This one. This one here.
Yes, that is an
What is that?
That
I
is an
carry my own with me.
exceptional resource value wetland with a 150-foot buffer.
Okay, and they are...
Actually, I'm sorry, let me rephrase that. That is not a wetland. It is state open waters. There's no wetlands there, and those state open waters have a 150-foot riparian buffer. So I apologize. I said wetlands, but those are designated as state open waters on the plan. They are not wetlands.
So when I think of open waters, I think of the high seas or a large lake. What does it mean in this case, open waters?
In this case, what it's referring to, and we're at the headwaters up here. This is the top of the mountain for this particular range. So everything from this site's draining off. We really don't have anything draining through the site. It's draining off of the site. So those are really what are considered ditches or small streams that have defined bed and banks associated with them. And typically there's water flowing in them. You may have times where we haven't had a lot of rain. They may be dry. But typically there's usually water flowing in those streams, in which case the state designates them as waters of the state. There's not a wetland buffer associated with them, but there's a riparian buffer under the Flood Hazard Area Act that's associated with them.
Thank you for that explanation. Actually, I'm going to correct you as someone who's been involved in Hillsborough Township's Environmental Commission probably longer than even Mrs. Boyer and Planning Board. I can tell you that the wetland you're referring to at the bottom is exceptional value. Here's a copy of the original maps that were done, because for something like 2 decades I sat on the technical advisory committee for 3M. And, sir, one other item, and that is that that particular wetland down at the bottom, we call it the mother of all wetlands, and it can even be shown, it can be seen, actually, board members, from 5,000 feet above sea level. And it's pictured quite easily in the SUSCD soil survey. It's particularly important because, as you know, and I knew you were going to tell this to the board, that these wetlands are critical and exceptional because they do 3 things. Number 1, they're the cheapest form of flood control. They slow down the water. Number 2, they're like a bathtub. Don't bend it, by the way. They're like a bathtub with a small hole at the bottom. That means that water flowing into it trickles out slowly, and it cleans the water because it goes through the biomass that's in that wetlands. And it's also the habitat, which ties in with something else. The habitat is the endangered species. threatened and endangered species. But back to this exceptional value, my concern, board members, is that that map that's being submitted and will be part of this file, that it more clearly indicate which are exceptional. That's what I want. And by the way, go ahead.
I'd just like to point out, I
go
don't
ahead.
disagree with a lot of your comments, but however, the area that you're referring to, I want to be clear on this.
Right.
It is not a wetland. The wetlands are further to the northwest of the tailings pile. This area down here that's shown in blue, but that area that you're referring to there is actually, and I off my pointer. Give me 1 second. I want to point it out to the board where that is. That area that you're referring to, and I don't disagree with you. That's an exceptional resource value wetland, certainly. That area is up here. It's to the north. It's to the
Correct.
northwest. It is not to the south of the pile,
And
which is
the area
the
right
state open
below
waters.
is 8-foot-high Phragmites, right down at the bottom.
Yes, but the wetlands that's being referred to is off. Actually, goes off the plan in a westerly
But
direction.
you know
in this
what's
way.
interesting about the board, to the board, is that just because there is a line there indicating here's Hillsborough, here's property belonging to the quarry, you still have to continue the line over into the quarry land. It doesn't stop there. It's on both sides. And your map, one of your maps, shows a 150-foot buffer, but gosh, it cuts off. It's only on the other side, but it's not on the quarry side. Okay, may we agree to disagree? And also the fact that despite what you just said, these headwaters, that's what they are. They're headwaters, and the area of the Saralin Mountain, I can swear and testify to the fact that water moves laterally down the slope and opens up, comes up to the surface where there are seeps, springs, and sumps and intermittent streams throughout the seasonal high water period. Okay, let me move on. The second thing I have a question here is, where do you show the county open space lands? The county owns a lot of land up there. Where is it?
It's my understanding it's off to the west of the plan, but that's not the focus of the plan I have up there.
Well, interesting enough, I'm looking at Chapter 160 Environmental Impact Statement, and it says that all the consultants have to provide a separate written description and analysis of all possible direct and indirect effect developments will have on the site itself, as well as adjacent and non-contiguous areas, with particular reference to the effect of the project on public safety, health, and welfare. So back to my question, even though it's not the immediate concern of your quarry, you're supposed to show county open space because whatever flows from your property might, who knows, impact the county. This happens to be. I'll be happy to share with you my PDF on this that I just received from the county. All the green. Hold it out. You see that? Maybe the camera behind you. All the green area. And by the way, we have thanks to Judge Tommy Miller for that one. He helped to negotiate that purchase.
And if you're looking at our EIS again, the way our project is designed, our impact is essentially the development footprint where we're putting the panels. We're not proposing any. We're not even stating there's any impact beyond the limits of it.
Okay, so
the site is
you're
isolated
suggesting
to the top of the
that all impacts should focus on just that pile, just the solar?
No, I'm suggesting the conclusions in our reports are that because of where we're putting this facility, the impacts are only limited to the top of the tailings pile. Beyond the tailings pile, we're not proposing any
But sir,
changes.
didn't you just say that the runoff is diffuse and that it runs in all directions?
Yes, the runoff comes off the tailings pile, comes down a series of pipes that are on the slopes of that pile, and it ends up in a series of ponds that are at the base of the tailings pile that is part of an Egyptes permit that the quarry has in place to manage the runoff from the property and to control the sediment runoff that could occur during storm events where that sediment is trapped in those ponds and is allowed to settle out before it leaves the quarry site.
Well, sir, I wasn't going to bring up the Egyptes permit right now. I have that way down my list. But as long as you brought that up, could you tell us about the Egyptes permit that this quarry now has? Are they in compliance?
From discussions with the quarry, I can speak anecdotally to the permit that they are in compliance with the requirements of the permit and what it's intended to do. I can't get into the specifics of all the details of it because we were just looking at the tailings pile itself, but there is a permit in place that requires them to manage runoff that comes off of the property, not only just from the tailings pile, but from the quarry operation itself.
Okay, I wasn't going to bring this up right now, but I happen to have an email I just received at 2:58 p.m. this afternoon, and it says PEG. And this, by the way, is from the chief inspector of for the Nagyptes permits and also state open water. It says the ACO. Do you all know what an ACO is? It's an administrative consent order for this facility remains effective. The water discharged via permitted outfall 003A remains high in TSS. That means total suspended solids and turbidity. This will not change until the proposed construction of a closed loop clarifier treatment system is put in place. Let me skip back to another one from the same man. The permittee, Construction Dynamics, became permittee after a permit transfer of ownership effective date 6/16/09. Don't worry, Richie, I'm almost finished. The subject permit is for the R13 mining quarrying activity. It was determined that the quarry could not meet the TSS limits of 40 milligrams per liter at the outfall. I'm going to skip over this, but so far the quarry has paid in excess of $65,000 for TSS exceedances. Okay. The point I guess I'm trying to make and I clarify with you is, do they have a permit? They have a permit. It's an administrative consent order, which they've had for 7 years. And because they could not meet the limits, they were granted a force majeure. Mr. Attorney, I think that's a... wake him up a little. Wake him up a little. Shove him, he's asleep. Yeah, I know you hear everything I'm saying. I think that's subparagraph 19 of the law, that they are now under a force majeure to try to clarify this. All right, so back to our consultant.
And for the purposes of the record, I'm really starting to get concerned. I realize that the objective is to give the public as much leeway as possible. But, and I'm starting to sound like a broken record today, the project is X. That's what we're here for. And the history of the environmental issues related to the 3M site and its successors is not necessarily, unless Ms. Van Patten would like to tell us what's germane about this application as to the Nagyptes permit, we could probably move on.
Well, Mr. Bernstein, may I please ask him questions about the things he said, directed to that?
You have more than that right. However, the last about 5 minutes has had nothing to do with his testimony.
I don't think it was 5 minutes, but okay. All right, so the critical areas, the wetlands you have clarified, 150 feet, and there are critical areas here that should be marked more clearly, I believe, on your map. What about the edges of that? I've heard 3 different numbers given. Mr. Maskey, in his report, talks about a 35-foot setback from the edge. The Environmental Commission says 20 feet from the edge. Your engineer says at least 200. What do you say?
As far as the setbacks are concerned, the simple numbers are this. 25 feet from the top of slope to the nearest fence line is the first primary setback. Then another 10 feet from the fence to the closest panel. So that's 35 feet from the top of slope to the closest panel, edge. Then there was talk in a report about 200 feet, but that 200-foot setback was actually measured from the bottom of the slope at the base of the panel, the base of the tailings pile, inward as a setback line. And clearly, the facility is more than 200 feet from the toe of the slope. into the site. So really, the setbacks that control are 25 feet to the fence and 10 feet to the nearest edge of the panel.
Would you please clarify, you talked about the slope being 2 to 1. In terms of percentage, what percent slope is that?
I think it's 2.5 to 1, and again, it's over 30.
So we're talking about a 20% slope, a 30% slope, a 35%?
No, it's between 35 and 45% slope. That goes
35%
down.
slope. Well, maybe the attorney could clarify some of these reports and get them to reconcile them, because I'm reading right now, based on the results of their study, the engineers recommend that the solar panel field, as well as all construction equipment, be kept at least 200 feet away from the top edges of the stockpile due to concerns about potential slope failures along the steep stockpiles. So how do you explain
Van
that?
Patten, hold it. As I said, maybe. What report, when drafted, who by?
Sorry, you're right. You're absolutely right. This is general.
And has the applicant seen it in order to allow Mr. Michello to testify as to it? Because while your testimony is not expert, Mr. Michello and his
Right.
license are.
Okay, I'm referring to Geotechnical Engineering Report, March 2015, KDR Solar, prepared for, and this is page 1, last paragraph. This was, all the board members have this report.
Mr. Michello, can you answer the question?
Yes, I can. What's being referred to here is the GTA report that was prepared specifically for this project by our geotechnical consultant. And what this is in the background paragraph on the bottom of page 1. And what's being done here is our geotechnical engineer was actually referencing a previous study that was done by Langen Engineering originally a couple of years ago. Langen's original conclusion in that study was to, and as I quote from the report, and I'll paraphrase, Langen Engineering recommended that the solar panel field, as well as all construction equipment, be kept at least 200 feet away from the top edges of the stockpile due to concerns about potential slope failures along the steep stockpile side slopes. That was Langen's conclusion. And
Mr. Michello,
yes.
just so we try to maintain a record, what's the date of the Langen report?
The Langen report in this is referenced to August 22nd, 2012.
Does it relate to the application currently before the board?
It does indirectly, but yes.
Indirect, but is it identical to the proposal now before the board?
I have not reviewed that whole report, so I can't say in its entirety if it is directly related to it.
Thank you.
But what I can point to is that was their original recommendation, and the purpose of the updated geotechnical report that was prepared by GTA was they went onto the top of the tailings pile, took samples of that pile at different locations to do a new geotechnical analysis to determine that the panels can be placed on top of the tailings pile. And they came up with different setbacks that they recommended to us for the placement of the panels on top of the tailings pile. So the original recommendation was 200 feet. They came back and said, no, you can do something different. That's the purpose of this report, to summarize their findings for the purposes of this application before the board tonight.
Mr. Chairman, I don't wish to intercede on the board. Does Mr. Brown have any comments on the setback issue other than what's proposed?
No.
Sir, are you confident that putting the fences or solar panels close to the edge of this, what did you say it was, 25, 30% slope, would, as close as you've mentioned here, that would be safe?
Yes, in accordance with our engineer's calculations that the geotechnical engineer did, that we feel that is adequate for the construction of the facility.
Mr. Schatzman, are you going to present the author of this as one of your witnesses?
No.
Okay. Next question, then. You talk about gravel berms. Can you explain what they were used for, and are they still there?
There is a series of gravel berms, and I'll refer back to exhibit. We'll use exhibit A6.
You might want to take,
I'm starting to get used to it now. Exhibit A6, which is the modified site plan rendering, which shows the aerial. There's a series of gravel berms that are on the, I'll say, eastern side of the access drive that comes from one of the internal quarry access drives up to the tailings pile. Those gravel berms are a foot and a half in height, and they're there to slow down the stormwater runoff as it comes down the stormwater runoff from the tailings pile as it comes down that top of that pile along that drive once it gets down to the bottom.
Sorry. Do you intend, or are you recommending that they be removed?
No, we actually stated as per Mr. Brown's review letter that they be maintained if they're dug through for the conduit to be put back once the conduit is in place.
Okay, may I please ask you a question? You made a comment about the calculations for the solar panels, and in the center of that there are little squares. Are they the inverters, the inverter foundations, and what are they?
In the center of the facility, there's 3 concrete pads. Those are the concrete pads that will support the inverters, the transformers, and the switchgear.
Are they part of the calculations for impervious coverage?
Yes, they are.
Senate Law 921 PL 2010, Subchapter 4, approved April 22nd, 2010, says that while the solar panels are indeed exempt from stormwater runoff, that the inverters, the foundations, and ancillary buildings are to be calculated.
That is correct. And as a matter of fact, that the 1,200 to 1,300 square foot of concrete pads that are being proposed are being offset by the removal of the existing compacted gravel drive that's up there on top of the tailings pile, so we have no net increase in impervious surfaces on top of the tailings pile.
In your calculations for runoff, do you include those steep, critically steep sidewalls?
Yes, we include the slopes are looked at in terms of vegetation, and there's no change to those slopes, so there's no change in runoff from those slopes.
I want to ask you a quick question about the fire official. The last time you were in front of this board, Gibraltar Quarry made what I thought was a very generous offer. You offered to give our fire officials a Polaris fire truck, fire equipment for emergency purposes. Has that offer been withdrawn?
I can't speak to that. I wasn't here the last time. I'd have to defer to our attorney.
Oh, okay. Okay, is anybody, Mr. Schatzman, going to get a free piece of equipment for the township?
We're not asking for it. Did anybody here ask for it?
What was the answer?
No piece of equipment.
No.
No, because...
Mr. Schatzman, on the microphone.
I'm sorry.
The reason being is when we, as Mr. Marcello, when Mr. Marcello testified, he said that, they met with the fire official, and what he testified as to what we're doing for emergency access, including the fire equipment, and the fire official was satisfied. That's what we're doing.
What has changed, Mr. Schatzman, between the last application and now?
Location.
Just the location?
Yeah.
I wish personally, I wish you would reconsider that one. Okay, the next question I have, sorry, Mr. Attorney Bernstein. Okay, the next one I want to ask you is, how about alarms? Are there going to be alarms up there?
There's no alarms,
No, it's
audible
okay.
alarms.
Yes or no? Okay. Visual impact, you showed us several pictures. What about visually from Blauenberg or from Skillman Road on the other side? You're talking about one side. What about this side, the southeast side? Can it be seen visually from Blauenberg, from up at the corner? One World Pizza up there? Can it be seen?
No, based upon our viewshed studies, you're not going to see the panels from the surrounding road network. It's based upon both distance and as you look at the top of the
You mean even
panel.
though it can be seen quite well now, it can't? It's not going to be seen?
The setback of the panels from the top of the slope pretty much excludes the visibility of them from distance.
Oh, okay. The next one about seeding. There's a cap on that. It's no longer used, supposedly. And what about a cap? How many inches of soil did your study show is on that? How many inches of soil, according to your reports?
Yeah, the geotech report mentioned about 1 to 2 inches of soil was placed on top of the cap when they did the test pits.
So you're proposing, and you think it will be successful to seed on top of 1 or 2 inches of soil, topsoil?
Well, we're only going to seed the areas that we would dig through for conduit or disturb. We're not going to reseed the entire top of the tailings pile. So we're talking about disturbance that's well under an acre. And if we do have to seed those areas, we have to put a couple more inches of topsoil down. We'll certainly do that in accordance with the soil
Does the
erosion standards.
township allow the importation of soils? I thought there were prohibitions about that. What does your research show?
It's my understanding that to bring topsoil onto a construction site for purposes of
Really?
of landscaping is permittable. I mean,
Are you aware of how long it took to grow the seed on that 35% slope?
I'm not aware of how long it took to grow the seed on the
Seed,
slope,
grow
but
the
we're not disturbing the 25 to 35%
No, but you're
slope.
you talked rather, are you sure of yourself that the seeding would take place on the top of that 1 to 2 inches of soil? Because I'm concerned it took 5 years to grow anything on the inert, inorganic material on the side slopes. Which brings me to my last question, well, not really, but my next question, in the composition of that material on the spoils pile. What is it anyway? What does your study say?
It's our understanding it's the byproduct of when they were processing roofing shingles over a number of years, and it's the crushed up rock, if you will. It's a fine powdery type of material that's placed in the ground. I believe the bag that you have there may be a sample of that, or maybe.
You mean this bag of talcum-like soil? But it's not soil at all, of course. All right, so your study says, however, that it's made up of rubble, of gravel, of clay-like material, and something they call, your reporter calls, or your engineer calls, deleterious material. What the heck is deleterious material?
That was his explanation for it. I can't. What
I mean,
the makeup of
pipes,
that is.
old cars. So in any case, it's deleterious, and that's what this inert material is on top. Last question, seismic activity, the blasting. Will the blasting affect the size of this precarious slope?
Again, this application is not proposing any impact to those side slopes. We're not touching those side slopes in any
I
way,
didn't
shape,
say
or
that.
form.
I
So-
said you've got weight on top, you've got the panels up there, you're doing activity. Will the blasting in any way affect those sidewalls?
I can't answer to that question. I did not look at it.
Your
in that
studies
regard.
have engineering, is certain of its, and has anybody looked at the adjacent major geological slip called the Hopewell Fault? It's right off the site. What impact would that have?
That's something we need to talk about, Aaron. Okay, thank you.
No one speculated on that?
We did not.
Okay.
There's the key word. No one has speculated. We are
And
not
written about
involved
it.
in speculation.
And
We are
written about
involved in
it.
testimony and evidence. Anyone can speculate on anything, but this board is not entitled to nor should be hearing speculation.
I'm sorry, Mr. Bernstein. Some people get paid for speculating. They're called sometimes engineers. Thank you, sir. Thank you, Mr. Schatzman. I have this back.
For those of you
Just
who-
civil engineers.
You're not chemical.
Mr. Chairman, is there anyone else from the public?
Steve?
Yeah, anyone else? No. I know that there isn't, because I can see that there isn't anyone else from the public.
For the record.
Huh?
Gee.
Well, he's the media, not the public.
Motion to close.
Although he could ask a question if he wanted to on the
Are
record.
there any other
but,
witnesses, Mr. Schatzman?
No other witnesses? Okay. Of what, Peg?
She's kidding.
Okay.
Motion to close.
Motion to close public hearing.
So moved.
Second? Is there a second?
Second.
All in favor, say aye.
Aye.
Okay. So...
Any last words, Mr. Schatzman?
Yes. You can sum up, sir.
You've heard the testimony, it provides 3 megawatts to use the quarry, remove it off the mountain, so to speak, not touching any vegetation that was, or minimal vegetation, no trees are coming down. It eliminates fossil fuels, it's a permitted use. We're only asking for basically a waiver of the community impact statement under your ordinance, which is self-evident because we're not putting school children or traffic or anything else. You know, it's the thing to do now to eliminate fossil fuels, especially when you don't have any cutting of the trees, and that's the application.
Thank you. You got Mr. Merchant, Sue?
I just wanted to say I've been up there, and I could see from being up there that the visual sight of it from down below, you're really not going to see anything. And I was at the 35 feet, and I was at the fence line, and I'm very impressed with the application. It's the right place for it. It's probably the best place in the township for it.
Oh, absolutely.
You know,
The thing about visibility is it's on the top of already an artificial mountain. And can you see the artificial mountain from far away? Yes. But this is on the top of the flat top of that mountain. So that's the reason
And
it's
also
not...
the site is flat.
Right.
And so it's like perfect.
Right.
If we're ready for a motion, I'd like to move that we approve it.
Sure, we're ready for a motion.
I just want to ask a question. This is for my own curiosity. It has nothing to do with the application. Is this just for your own consumption, or are you throwing on the grid?
Yeah, I was going to ask that.
This is for our own consumption. They use approximately 3 megawatts, and the power is going back into the quarry. It does go technically into the grid because it runs the meter backwards, but it's based upon their own consumption.
So Saturday, when you're not running, it'll be feeding the grid.
Technically, yes. As their meter spins backwards, technically is what they call it.
Can't feed the
Again, it has nothing to do with the application. I was just curious.
Yeah, the motion would be also to include the waiver for the community.
And any and all other agreements that...
Yes, right. Oh, yeah. The whole kibosh. And it has nothing to do with moving the fence or anything like that.
But they are putting on an 8-foot fence.
I know.
Yeah. That's right.
It's
we are.
galvanized.
So it must be legal.
In spite of what Bob Heibel said.
Oh, God, he had a rough day today, didn't he?
First time I've seen him.
He was, I hate to be the one to catch him, too, but I did.
You did.
We have a motion in a second.
Yes, we do. We do indeed. Roll call, please.
Get a Colby. I would have.
No, public hearing's closed. The point of order is you're done because the public hearing's closed. Yeah.
Don't be sorry.
Mr. Wagner?
Yes.
Dr. Morelli?
Yes.
Mr. Connor?
Yes.
Mr. Reitinger?
Yes.
Mr. Lepani?
Yes.
Vice Chairman Collins?
Yes.
Committee Man Belcourt?
Yes.
Deputy Mayor Burchett?
Yes.
Chairman Dr. Sweet.
Yes.
Thank you for your time.
Thank you. You have some communications, board members, from the SCPB. A letter from the resolution from the Somerset County Planning Board, and proposed changes to wastewater management planning requirements. Other than that, our next meeting is December 3rd, yes?
Yes.
Okay. Motion to adjourn?
So moved.
All in favor, say aye.
Aye.
We are adjourned.
Happy Thanksgiving, folks.